We're delighted to have you here for this discussion with Colleen Connell from the Illinois American Civil Liberties Union. My name is Carole Levine. I'm a board member of Chicago Women Take Action and the chair of Courts Matter Illinois. Let me start by giving you the title of this session, which is The Current State of Our Constitutional Rights in Chicago and in Illinois. And I'm going to start with a brief introduction of Colleen Connell, who is the executive director of the American Civil Liberties Union of Illinois, an organization that she has been with since 1984. Prior to becoming the executive director, Colleen served as the ACLU's associate legal director and director of the Reproductive Rights Project. And in that capacity, she directed the organization's litigation efforts involving constitutional rights of privacy and protecting the rights of Illinois citizens to make decisions concerning reproductive matters and childbearing without undue governmental restrictions. A native of North Dakota, she was graduated from North Dakota State University and the University of Iowa School of Law. So that's who Colleen is. We're delighted to have her here to talk about where we are constitutionally here in Illinois, which is really considered a good state to be in. But many of us, who myself included, live in areas where we've seen our neighbors snatched up and taken away, have concerns. So let me start with a question for you, Colleen. Can you just give us some background on the role that the ACLU of Illinois has been playing since the federal government has targeted Chicago and the surrounding area for its deployment of the National Guard troops from Texas and Illinois to protect federal immigration enforcement operations?
Yes, I can, Carol. I'm going to divide it into a few buckets, one being litigation, one being sort of public speaking, know your rights, the third being working with board members and community groups. Because I think it's really important for everyone to appreciate that we all have a role to play here in protecting our neighbors, our families, and our communities from what has emerged as a very abusive federal immigration enforcement uptick that has, as several federal courts have found, violated the constitutional rights of people. And so I'm going to start with the litigation. The ACLU of Illinois is involved in 4 pieces of litigation that have had a significant impact on protecting people's rights. The first one is the Kasten and Nava lawsuit, and that goes back actually to the first Trump administration. And that lawsuit ultimately resulted in a federal court consent decree that prevented federal immigration agents, ICE and Customs and Border Protection, and the other enforcement agents that are part of the Department of Homeland Security. And I'll probably use DHS or ICE to encompass everyone, from making arrests of folks solely on the basis of the DHS agents' assessment that that person was in the country without appropriate immigration documentation. What the consent decree of federal settlement directed was people cannot be detained unless ICE or Customs and Border Protection has a warrant for their arrest. Or ICE has probable cause to believe that the person who they want to arrest will flee the jurisdiction during the interregnum between being stopped and the opportunity for DHS to get a warrant. And there was a significant development in that case on Wednesday when the federal judge who's hearing this case directed DHS basically to show that they had good reason to keep in detention the 615 people who currently are in detention and who have been arrested without a warrant. And this case really recognizes what you were alluding to in your opening remarks, Carole, which is that so many of the people who have been caught up in this enforcement blitz are people who are our friends, our neighbors, and who have been in this country for years, if not decades. And they have real ties to the community, which is why the judge said you have to have a warrant for their detention, because these are not people who are just going to abandon their families and abandon their ties to the community. And so that's one piece of legislation that has a real impact on people's rights. And so if folks know of anyone who has been seized without a warrant, reach out to the ACLU or our partner in this litigation, the National Immigration Justice Center. If you go to either of our websites, there's essentially a complaint form that you can fill out to begin the work to challenge that detention. The second piece of litigation that the ACLU is involved in is a case that goes by the name Chicago Headline Club. This has gotten a tremendous amount of press coverage, in part because members of the press are plaintiffs in this case, but more significantly because the facts in this case are so outrageous that they warrant really significant coverage by the press. This Chicago Headlines Club case started initially with the abusive ICE actions that were taken initially in proximity to the Broadview Detention Center, which, as immigration enforcement ramped up, was detaining more and more people, but was also the subject of a huge number of protests. These protests at Broadview have been going on really for years, but as immigration enforcement ramped up, so too did the protests. And they were, by and large, remarkably peaceful. You know, I'm sure everybody saw the coverage of the suburban moms and the clergy people and the people who appeared in costumes. I mean, these were people who were exercising their First Amendment right to assemble and to protest government actions, because that's what they were protesting, government action. And of course, there was press coverage of it. What happened and what the federal court basically has prohibited is that ICE essentially responded with excessive force and was very hostile and aggressive towards, by and large, peaceful protesters and the press who covered it. And then to add insult to injury, the more coverage that occurred and the more people who engaged in this protest, ICE ramped up its retaliatory efforts directed at the protesters and the coverage of that protest. And so the ACLU, in conjunction with a number of other advocacy groups and the Lovie Law Firm here in Chicago, filed a lawsuit challenging on both First Amendment grounds which is obviously the protection of the right of speech and press, and Fourth Amendment grounds, challenging the excessive force with which ICE was responding. And when I talk about excessive force, what we were seeing first at Broadview and then ballooning out into the Chicago area with all of the ICE arrests was the use of riot control weapons that are ostensibly quote unquote non-lethal directed at peaceful protesters. So we see tear gas being fired, we see pepper balls being fired, we see flashbang grenades being used, all against peaceful protesters. And so this case initially resulted in a federal court entering a temporary restraining order. And then approximately 2 weeks ago, Judge Ellis entered a preliminary injunction restricting ICE's ability to actually use those kind of weapons of riot control, putting restrictions on the use of tear gas and pepper spray unless there's an imminent threat posed to the ICE agents or the public safety. And even then, 2 audible warnings are required to be given. And in a really significant additional restriction that was entered by Judge Ellis after hearing a day of testimony. The judge also barred ICE and DHS from using a chokehold like the one that killed George Floyd in the summer of 2020, and similar types of excessive force like carotid artery holds or kneeling on the spine, particularly in the neck area, of protesters or people ICE was seeking to arrest. And all this goes into, I think, the category of the extraordinarily excessive levels of force that ICE has been using against people who they are claiming to detain based on their immigration status, but also protesters and in some instances bystanders who were just observing what was happening to ICE. So the third piece of litigation that we're involved in is the Marino Gonzalez case, which challenges the conditions of confinement of immigrant detainees who are held at the Broadview Processing Center. The processing center was designed to hold relatively few people for fewer than 12 hours. It is not designed to be an overnight holding facility. It does not have a kitchen. It does not have adequate shower or bathroom facilities. And what transpired as we saw Operation Midway Blitz accelerate and the number of people detained increase is that anywhere from 300 to more people were held in a facility for days at end under conditions that the federal judge hearing this matter said are just plain flat out inhumane. People did not have beds. They were sleeping literally. When I say cheek to jowl, that is not hyperbolic. People had to step over the reclining, people in the cell to go to the bathroom. And there was not even room for people to recline on a filthy concrete floor. Instead, many people were really forced to lean against the wall or in a couple of cases, plastic chairs. The food was inadequate and in some instances inedible. and there were serious restrictions on the amount of potable water that people had available. And the toilet facilities were filthy and inadequate. We're talking about people being forced to use bathroom facilities without any privacy. There was maybe a privacy screen erected around this, around the toilet in the cell, but no door, no fan. I mean, it's just plain flat out inhumane, and that was happening right here in our backyard. And so, a week ago plus, a federal judge entered a temporary restraining order that required ICE to essentially clean up the facility, provide adequate food and water, provide adequate access to medical care and access to counsel. People were not allowed access to their lawyers, and in many instances were really coerced into signing waivers of rights as a condition of getting out of this hellhole. That case is going to go to a preliminary injunction hearing in December. The fourth piece of litigation that we're involved in, Carole, is the case that has the title State of Illinois versus Trump. And that is the case brought by the state of Illinois challenging the Trump administration's federalization of the National Guard and its attempt to deploy the National Guard in the city of Chicago. Another federal judge blocked the deployment of the National Guard. She did not block the federalization of the National Guard. She said, Trump can do that, but you can't deploy it in Chicago, because in large part what she found was that the Trump administration's dishonest effort to describe Chicago as a dangerous, crime-ridden city where immigration officers could not enforce the law was untethered to reality. And Judge Perry relied really on a lot of the facts that had been put into evidence in the Chicago Headline Club about the peaceable nature of the protests that have gone on in Chicago and in the Chicago area for months now. And so just Monday of this week, so 5 days ago, the ACLU of Illinois, in concert with our national office, filed an amicus brief, really talking about how the deployment of the National Guard in the Chicago area would chill constitutional rights. The procedural posture of the Illinois versus Trump case is that, as I indicated, Judge Perry blocked the deployment. The U.S. Court of Appeals for the Seventh Circuit, which is the appellate court that covers Illinois as well as Wisconsin and Indiana, refused to stay or block Judge Perry's order. So it did not give the Trump administration the relief that it requested. And so the Trump administration, as it is wont to do, has run to the Supreme Court and asked the Supreme Court to basically stay or block Judge Perry's effort, order blocking the National Guard.
I'm going to jump around a bit in some of my questions, but it seems to me that the courts, the lower courts, not the Supreme Court, have been very, I use the term good, and following the law and upholding the rights of the constitutional rights of the people in most of the cases that you're dealing with, that we're seeing in relationship to the protests and what is happening here in Illinois in relationship to these events. What I'm concerned about, as you said, is that the Trump administration is running to the Supreme Court. Is from your perspective as an organization that deals with the legalities here, are you seeing that as the case, that the lower courts seem to be on target in terms of what their findings are, but
Yes,
and
yes, you are absolutely correct. And that is how we are seeing it as an organization with lawyers in all 50 states. And so we are seeing that definitely on the local level where ACLU, state ACLUs like Illinois are filing actions. We are seeing the federal district courts appropriately apply the law to the facts that the lawyers on the ground put into evidence in conformity with the rules of evidence that all of us lawyers have had to operate with for all of our legal careers. And then what we are seeing across the country is the Trump administration's use of the Supreme Court's shadow docket to try to get an emergency stay of the lower court issued in often TROs, temporary restraining orders, or preliminary injunctions. And what is so both disingenuous about it and disturbing about it is the real impact on people, but also the distortion of, quite frankly, the rule of law and the Supreme Court's shadow docket. And so dealing first with the impact on real people, and going back to the kinds of evidentiary showings that lawyers put on at the district court or trial court level. These are affidavits or declarations, and in many cases, live testimony of people who are testifying under penalty of perjury. And they are talking about, for example, going back to our Broadview conditions case, the fact that one of our clients was unable to lay down at night until somebody got up to use the bathroom, and then he could use the space on the floor that person had vacated. We had people testify about how they had to sleep next to an overflowing toilet because there was no other place to sleep. We have declarations of parents whose young children have suffered from tear gas, or the parents themselves, because ICE agents lob tear gas in their enforcement efforts. This is real live stuff that's happening to folks. And the federal courts have credited this as truth. And in the face of that, the Trump administration's toadies, there's no other word for it, have lied, and the federal courts have found them to be lying. And so the evidentiary record is solid about the constitutional violations that have been proved. And then it goes up to the Court of Appeal, to the Supreme Court. And the Supreme Court does not hear new evidence. That is not the Supreme Court's role. The Supreme Court is not actually ruling on the underlying merits of the case of whether ICE violated people's rights. Instead, it's basically issuing an order blocking the district court TRO or injunction, in most cases without providing any rationale. And that is just an abdication, and quite frankly, it's more than an abdication. It's a violation of the Supreme Court's role. I mean, they're only supposed to issue this kind of emergency relief when there's a balance of equities that shows that the person who's seeking relief will be hurt irreparably if that relief isn't issued. And, as I've just laid out, the equities are completely on the other side. But from a jurisprudential matter, which I know we both care about, given your longtime work with Courts Matter, and you are so right about this, to issue these orders without providing guidance to the lower courts is what I was really referencing when I used the word abdication. That's the Supreme Court's role. And what has caused a tremendous amount of consternation in the lower courts is that the shadow docket is not supposed to have precedential value. And it is even harder for it to have precedential value when the court doesn't give much reasoning, if any at all. And then the Supreme Court, in a couple of notable incidents, has said to lower courts, you're in violation of whatever we ruled on the shadow docket, even though we didn't give you a reason for why we were ruling that way. And so it just is a complete disregard of what we call our common law based system, where the power of the judiciary is in its reasoning, Carole. And lower courts, as they should, look to the reasoning that has been laid out as sort of the final word by the ultimate decision maker, the Supreme Court. And when the court doesn't give that kind of rationale, it basically says to the lower courts, either read my mind, which of course is not possible, or leaves the Supreme Court open to the legitimate criticism that what lower courts are supposed to do is follow what the Supreme Court is doing, which is always rule for the Trump administration, regardless of the merits.
So given that, it leaves from what you're saying, it leaves our court system in disarray,
Yes,
so to speak, and it leaves us as citizens sort of at loose ends. So my
right.
question is there anything, or what can we do? Are there things that we as citizens can do? I mean, we can go to protests, but yesterday we looked at going over to Broadview, but quite frankly, we didn't have the right equipment. We didn't have gas masks. We didn't have things like that we were told you should have these things if you're going to Broadview. And so what can we do that might be helpful?
So I think everything that you're doing and thinking of doing is helpful. I think that there are people at Broadview every day, and that is really good. And the use of tear gas and pepper balls and other types of chemical weapons by ICE and DHS has really subs, you know, basically receded after the order, at least at Broadview. Um, I think the kind of organized marches, like the really successful No Kings rallies, are hugely important because there's a significant body of scholarly research that shows that when you get, 3% or more of the population in the streets protesting peacefully, that begins to have a real impact on decision makers. Maybe not the Stephen Millers of the world, but it does on decision makers. And it also provides that kind of evidentiary material that's useful in court of, again, the facts show that these are peaceful protests. They are protests against the government's abusive or unconstitutional policies. Really, really important. I think that the, other list of things that people can do, and this is where I'll go into sort of that second bucket of working with neighborhoods and community partners is really important. And I want to lift up the work of a number of organizations, including the Illinois Coalition against Immigrant, the Illinois Coalition of Immigrant and Refugee Rights, ICER is what the acronym, OCAD, the Organized Communities Against Deportation, the Resurrection Project, North Suburban Legal Aid, PASO. There are a whole range of grassroots organizations. Some of them are neighborhood based, some of them are regional based, Southwest side, Northwest side, but who are really organizing communities to express their opposition to what's happening and to provide safety for community members. Because what we've also seen is that ICE is indiscriminate in who it goes after. And we've seen US citizens detained and force used against them. We've seen people who have immigration status, like, for example, temporary protected status that doesn't expire. We've seen people who are lawful permanent residents seized, indiscriminately. The daycare worker who was seized in sort of the North Center neighborhood of Chicago had work authorization based on the record. And so for, neighborhoods to really try to, show up peacefully to protect their own is really, really important for people's safety. Some of the things that we've seen in the Chicago area have included neighborhood groups walking children to and from school. Hugely important. We've seen neighborhood groups organize Know Your Rights sessions where people learn about, you know, you don't have to let some law enforcement into your home or into a private space in a business unless law enforcement has a warrant. And you can insist on seeing that warrant. It has helped people who have uncertain immigration status prepare for the awful situation where they might be detained. And many families are what we call mixed status families. Some members of the family may be undocumented or have uncertain status. And we see a lot of young people who are US citizens. They were born here. And how to prepare a family emergency kit so that if the parents are taken into custody, there's a provisional guardian who can make decisions for the children who are US citizens about medical care, about school matters, things like that. And then I think one of the other things that we can and must do as a community, and when I say community here, I'm talking about an Illinois community, I think we need to support the commercial districts of neighborhoods and cities that have been hard hit by the immigration enforcement efforts, which have been indiscriminate, and have left many people of color apprehensive to go to work, to go to grocery shop, to go out to eat, even if they have lawful status, because they look Latino or they look Asian, because we've seen ramped up immigration efforts in the Chinatown area. And we have, the ACLU of Illinois has board members from a couple of the, hugely impacted communities, one being Little Village and one being a Belmont Cragen. And, changing our routine and going to dinner in Little Village as opposed to down the block every once in a while, or shopping in Little Village or Belmont Cragen, and really trying to be a bigger community than our own insular neighborhoods, which again are also important in terms of supporting these efforts. But I think that there's really a lot that we can do. And I think that what we have seen, again, going back to community efforts, have been things like people volunteering to deliver food baskets from folks who are too afraid to go out. And so I think showing up big time for our communities writ large is a really, really important part of protest.
Yeah, I think figuring out where your neighborhood groups are to see how they are organized. I mean, we've been on our school watch at our neighborhood school through the group. So, we were standing on a corner at Broadway and Thorndale, which is a block away from our neighborhood school, with our whistles very prominent,
Right.
and cars driving by are waving, applauding, honking at us,
Right.
just because we're standing there at release time from our elementary school. So there are things, just simple things like that, if you have time, that I think you can
Yes,
do.
and people do. And if you don't have time, I urge people to give as generously as they can, um, not just to the ACLU, and we are appreciative of those efforts, but to food pantries, to local neighborhood groups, to the grassroots organizations like OCAD
Um,
and
there-
ICER, who are really, in the neighborhoods providing this kind of support to your local places of worship. I mean, I have to say that I have been just so moved by how so many of our religious institutions have really stepped up um, by providing shelter to refugee families, by hosting Know Your Rights um, presentations, by one of our local churches. Um, and I live in the city in the Ravenswood Manor / Albany Park neighborhood. There was a community, sort of a pop-up community fair on Saturday with Know Your Rights presentations and connections to the different food pantries. And it's been across religions. I mean, the Catholic bishops yesterday or the day before issued a strong statement about the need to treat immigrants with humanity and really taking issue with the immigration enforcement efforts. I did a Know Your Rights training that was initially sponsored by the Presbyterians, but there were people, there were a number of rabbis there were a number of imams there were, sort of interdenominational Christian faiths. I mean, people and organizations just across the spectrum are coming up big to provide that kind of community support. And I think in the long run, and I say this frequently, there are more of us than there are of them. And as I've said to my husband, sort of repeatedly, you really see just um, uh, looking at the events of the last 2 months, why an occupying force never wins, because there are more of us than there are of them. And ICE and CBP were really viewed, as they should have been, as an attempt to be an occupying force. And it's just so wrong. I mean, it's anti-democratic. For another session, maybe we can talk about how Trump's effort to use, as powers of the presidency violate the limits that Article 2 of the Constitution place on the president, but also seriously invade the province of Congress and the powers that are specifically delegated to Congress in Article 1 of the Constitution. And going back again to your question of what can people do, vote. The way that Congress has abdicated its power during the past 10 months is despicable.
So let me ask you, as we look forward, looking forward to the midterm elections, both before, during the midterms, and afterwards, is the ACLU sort of preparing scenarios for what you anticipate might happen? I'm very concerned about those elections, and even to the point of, will they actually happen given this administration?
So, yes, the ACLU is planning. I share your concern about, you didn't say it explicitly, but voter suppression, voter intimidation. We've got the gerrymandering issue out there. But I think the 2026 elections will happen. I think Trump wouldn't be so intent on pushing the gerrymandering if they weren't going to allow the elections to go forward. And again, this is one of those times where I think that there are more of us than there are of them is really an important reminder. I think it would be very difficult to suppress the elections in all 50 states. And I'm going to compliment Governor Pritzker for connecting the chronology after Bovino announced that he was pulling out, but that they'd be back in March. And, Governor Pritzker rightly identified, well, yeah, and that's when the primary is. And, there've certainly been, not very veiled threats by the Trump administration of, using force to prevent or protect against voter fraud, which quite frankly is non-existent. And, you really have to see that for what it is, which is an effort to intimidate people from going to the polls. And I think, going back to your opening remarks, we feel very lucky to be here in Illinois. This is not a state that historically has suppressed the right to vote. And I would urge, people as they think about the primary and as they think about the general election in 2026, to report any thing that you see that smacks of voter intimidation or voter interference at the polls, because the Lawyers Committee for Civil Rights as a office here in Chicago, they have a significant voter protection effort, and the Secretary of State and the AG's office also have significant voter protection details, and all will respond quickly to any reports of voter interference or intimidation.
And it is very easy and to become a poll watcher,
Yes,
things like that that you can do. And if you are not as concerned about Illinois, you can do this in other states where you
right.
are concerned.
That's right. That's
So
absolutely right.
yes, we've gone to other states to do poll watching.
Right.
And
Wisconsin and Indiana, to name two of our neighboring states, often are in need of citizen poll watchers.
and it's not too soon to start thinking about that.
Correct.
So let me first, because it's been almost 45 minutes, and I'm very grateful for your time, Colleen. Um, Let me say that there are a couple other things you can do. You can join the ACLU. That's my plug for you. You can join Chicago Women Take Action. So I do both. And you can then look for things, those groups in your neighborhood and those organizations that are doing actions. There are things you can do from your home, and there are things you can do with others in groups. Um, these are difficult times that call for people to take action as they can. That doesn't mean you have to hit the streets. It means you have to think about what you're capable of and do what you can do. Um, so I want to say thank you. I want to say thank you to Colleen for your all that you do and your wisdom and experience. I'm very grateful for your time, and I want to thank anyone who is listening to this, and thank you.
Carol, thank you for the opportunity again. It's hugely meaningful. And the last thing that I would add of what people can do is keep talking to your friends, your family, your neighbors, because the demise of independent news has contributed to, I think, the encouragement of the autocratic forces that the Trump administration really reflects. And we need to tell the truth to each other. And so I really applaud your efforts over the years and that of Chicago Women Take Action to keep putting that truth out there.
Yeah, and don't forget, you can also talk to your elected officials.
Absolutely.
They work for you.
Absolutely. And vote.
Oh. Thank you all.
Thanks, Carol. Happy Thanksgiving, everyone.